Okay, well, good morning, everyone. My name is Gabriella Kennedy. I'm the co-chair of the Intellectual Property Committee at AmCham, and I'm delighted to welcome you to this breakfast session. Thank you for getting up so early. Before we start, I've been asked by the Chamber to remind you the color scheme of our badges. You will have noticed that some of us have blue badges, which means we're members of the Chamber. Others have yellow badges. Hello, my fellow yellow badge member. It means that we are committee chairs. If you have a grey badge, you need to do better. You need to upgrade to blue and become a member of the Chamber. And you'll get benefits like being able to view online sessions like today's session, which is going to be filmed, recorded, and made available to all members of the Chamber who were not in town and not able to join us for this very topical session on the new pilot scheme for eDiscovery. We're delighted to have with us two specialists, AmChamHK, my partner at Mayer Brown JSM, who is co-leader of our international arbitration group and was a member of the working committee of the judiciary on the new pilot scheme for eDiscovery, which was introduced in September 2014. He's been involved in many arbitration and litigation cases, very complex, all very document heavy. So he's got lots of experience on discovery and certainly eDiscovery. And Nathan Hughes, who works for Epic Systems Asia, he's business development manager in Asia and has many years of experience on eDiscovery and the impact of technology on eDiscovery, not just in Asia, but also in Europe and in the US. And that's very important for us because we are at the beginning of a journey here. It's good to hear from people who have done a lot of litigation, and it's good to hear from people who have provided the technology support for litigation. So I'm going to invite our two speakers to start their session. They will tell you how they want to run it. Typically, we have a presentation and then a question and answer, but they may want to do it in a more interactive way. So.
Thank you very much to Gabriella and for the kind introduction, and to all of you for coming here at this hour. We certainly appreciate that we don't want anything too dry at this hour, so we'll try and keep it fairly light and conversational. And we'll just, some of the slides, both Nathan and I will talk about, and some he will, and some I will. And if anyone has a question and you want to ask it while it's still in your mind, please feel free to do so. We're happy to have an interactive conversation, or there'll be a dedicated time for question at the end. So just starting off, we wanted to kind of put a little bit of context to why we're here. I was very pleased to see that other than Gabriella and myself, I think there are no other lawyers in the room, because that changes the context. And we need to look at how do these legal processes relate to real people in real life with real corporate situations. And that's what I wanted to start off talking about. So what's discovery? Well, my kids saw that I was doing Discovery, and they said, "Is that on the Discovery Channel?" And I said, "No, it's a lot more boring than that." So Discovery is discovering, finding information, a needle in a haystack sometimes in the process of some kind of legal process, whether it be an investigation or an arbitration or litigation, or even an internal investigation. And so what we're really talking about here, and it just happened to come from US court processes that use the term discovery to find relevant evidence amongst a whole bunch of what's today called big data. And that used to be among a lot of pages of data. And now it's become all digital, and we need to adapt that. So it's relevant because everything that we do these days is more and more regulated, whether you're under a Hong Kong regulatory system, whether you have an interface with the mainland, or whether you are part of some kind of global organization, you're going to have a lot of regulators. And even if you don't go anywhere near a court or an arbitration, you will still have to have compliance, whether it be internal compliance or an external regulator asking for information. You've got to make sure that your data is in order. And saying, well, somebody sent an email on their iPhone, at 10 o'clock at night in a restaurant saying X, and we don't have a record of it, is not good enough. It will not be compliant. And so what we need to really do is twofold. Number one, comply so that within an organization you can trace exactly and how the data is stored and when it's retained and when it's deleted, and there's a system. And then secondly, if you're already going to do that, internally, the first question that's going to be asked in any big organization or a small one is, well, how much does this cost? What are we doing? Are we being efficient about it? How much server space are we using? What are the backups, etc.? Apart from that, you'll then have, well, if we are going to spend this money, what are we going to get out of it? Can we harvest our data? Can we analyze our data with all these analytic programs that are out there to look at some trends of what's going on internally within our organization, about productivity, about sales? What can we learn from all this great amount of big data that we've managed to store? So that's it from the lawyer's perspective. Nathan's very much on the practical side. Maybe he can add a few comments.
Yeah, so I think the key point that Manako mentioned there, everything is communicated electronically these days. So if you think about, the only time I write things down in an official communication is probably a birthday card. Everything else is electronic, like text messages, SMS, audio, emails, everything's electronic, and that's causing an explosion in the amounts of electronic data. Server space and storage is readily available. So the biggest challenge we're seeing is number one, corporations and companies understanding where their data is and communicating internally to be able to access that. And number two, being able to put their finger on it quickly and respond if there is a regulatory need or a litigation. Some of the driving factors are that Asia is increasingly under regulatory focus. So obviously China's under the microscope a lot for some of their practices. And then the banks have all been investigated globally. So that's, especially in Hong Kong, that's driving a lot of activity here. So we'll go into more detail later in the presentation about the different types of electronic data, some of the best practices for what we should do if there is an issue or a litigation that's kicked off, and what we do to start off that investigation.
We'll just look briefly at who are the types of people that are going to ask you for documents. And when we say document, we mean that in the legal sense of the word. One way of thinking about it is that some of you have already created a document when you walked into this building. Did you know that? Because there's a CCTV camera and it knows that you walked in at a particular hour. And if, for whatever reason, it became relevant to a regulatory or a court proceeding of whether or not you walked into this building at that hour, it is a potentially relevant document, that CCTV record. And if you manage a building, you have to ask, well, what's the retention policy here on the CCTV? Generally speaking, electronic records are asked for by a whole bunch of regulators, and we've given really only examples of those, the main ones that you can see from either Hong Kong or the US or China that are listed there in the square brackets. Apart from those, there are a whole bunch of financial and banking regulators that we probably need the whole slide to fill up. Exactly as Nathan says, if any of you are involved in the finance side of things or have people you know involved, they will tell you that they're spending an increasing amount of time with regulators, just making sure that they can comply and respond to investigations. There's anti-money laundering, there's anti-bribery. We'll touch later on data privacy, and increasingly in this region, antitrust competition with the new Hong Kong Competition Commission is becoming very much important for corporations in Hong Kong and China. One of the things that some of the more traditional companies ask us about is they say, well, but we still have paper files. If you're saying all of this is electronic, what are we going to do about our paper? And the answer is yes, you can, but if you look at the numbers, if you start thinking about audio files and videos and emails and text, it's well less than 10% of what's going on. So if you've got 90% and 10%, Nathan can cover it a bit later. The smart thing to do is, rather than printing out the 90%, digitize the 10%. And you'll see later on how that then will give you search functions and so forth.
I think to add to Menachem's point, like if you were to, like that last point there, 1 gigabyte of electronic data equals up to 70,000 pages of electronic data. So our iPhones have 128 gigabytes these days, so it's impossible to print things out. I had a client come in, was last year, the middle of last year, with a drive, 5 terabyte drive, and said, can you print that out for us? Which is, it's going to cost 10 times as much as an eDiscovery request, and you'd need a aircraft hangar to store all the paper. So I think there's actually a lot more than 90% of communication these days are electronic and not printed. So that leads us into what actually constitutes an electronic document. And we can compare it with a printed document. The key element is metadata. Who here knows what metadata is? A few, yeah. Metadata is basically the document properties, and there's a whole raft of different fields and properties that come with any electronic document. A lot of them are useless, but a lot of them can be very important and something that you don't see on the face of a document if you print it. So things like date last modified, date access to, from, all these types of things are metadata fields, and for a particular like employment case or an IP case, the metadata can be crucial. And that type of data is preserved at the collection point, and it actually constitutes part of the electronic document, even if it's not visual. So, and the other side can request that. So it's important to consider that if you were to print something out, as opposed to keeping it in what we call the native format. So if we look a bit further, traditionally electronic documents are the ones that we'd all know of, like emails, Microsoft Office type of documents. Your standard sort of electronic documents. We're seeing a lot more sort of new data types, if you like. Most of our requests these days will have cell phones, and from them we can preserve. People are interested in instant messaging type of chats. Everybody's chatting on like WhatsApp and chatting about work stuff on instant messaging. Audio, which Menachem touched on, and CCTV. These are all electronic documents. They all have their own metadata fields, and they all can be requested in a discovery format. And then to add to that, there's also different storage types. A lot of companies will be storing things in the cloud or on servers that may not be located locally. There's also, in China particularly, a lot of companies and bigger companies will use webmail, like some Gmail or Yahoo type of accounts, or the Chinese varieties of that. So all these types of things can cause some challenges when we look to collect and preserve electronic data.
Just to add a couple of things to that, I said before that a document is legally defined as including an electronic document. There is a decision of the Court of Final Appeal in Hong Kong to that effect. There's also some legislation, primarily the Electronic Transactions Ordinance, that gives a legal effect to electronic documents in Hong Kong. It's probably not very well known that an electronic signature is generally acceptable under that ordinance. If you sign something and there is a legal requirement for a signature, that legislation in Hong Kong tells you it's the same as if you signed it with a pen. Generally speaking, there are some exceptions, but generally speaking. The other interesting thing about documents in a legal context is that they are dynamic. And so Nathan mentioned the native format. And in a lot of those native formats, an Excel spreadsheet is a fairly basic example, is it can move because you've got these formulas and things can change. So you need to sometimes look at it as it was at one point in time, and then it will be something different. And that's where all this metadata is important. The other feature of documents, which is very relevant to evidence collection, is that digital data is much more difficult to destroy. If you remember, I think the old Enron days, you could simply put it in the shredder. But these days, you can shred as much as you like, and you're not going to delete all the electronic copies of it. If you delete it on this laptop, there is probably still a copy in the hard drive that can be recovered in some instances. If you throw your iPhone or Android phone into the harbor, it's not going to help you if things are on the cloud. There may be multiple copies of communications that are CC'd to people, so you might have 10 or 12 different copies of it in the one place. So that's all part of the process, is trying to get an understanding of where is the data, how much has it proliferated, and certainly anyone that tries to hide needs to be very, very careful about it, because they will find that the data is probably in a lot of places that they don't think or expect it to be. Moving along, we just want to give a little bit of a background of where we're going to talk about where Hong Kong is on this new practice direction. And I think the background to that is, where is eDiscovery at globally? So maybe Nathan can kick off with, he was in the USA doing discovery for a while. So I asked him to talk about a case called Zubilaki.
Yeah, so this was like a groundbreaking case in the US, and it's still referred to as case law in the US. It was Zubilaki versus USB Wahlberg, and it was a gender discrimination or sexual discrimination. This lady, Laura Zubilaki, was complaining that she couldn't get promoted. She was being discriminated against for being a lady in a male-dominated industry in the banking. And it got to the point where it had happened a few times. So she sued UBS, and obviously the emails were critical. There was a lot of emails between senior executives in the US speaking about why she wasn't being promoted, or she was forwarding it to her, executives. And this was a groundbreaking eDiscovery matter in the US, and is constantly referred to as case law. There was also issues around spoliation, so spoiling or tampering or changing the evidence, which Menachem just referred to. Did you have anything else to add?
I think on the Zubilaki case, what was very interesting there, we're talking first of all about 15 years ago. I think the decision, the first one came out in around 2001 or something like that. So we're talking about times where there was a lot less data around, and it was stored in a much more simple way. And a lot of it actually revolved around backup tapes. And somebody I know actually flew from Hong Kong to the USA with some backup tapes, because some of the data was stored in Hong Kong. But what ended up happening is that it was found that UBS had destroyed some of the backup tapes after the litigation had commenced. And a very important principle of litigation in Hong Kong, UK, USA, is that if you know there is relevant data and you know that it is likely that there will be an investigation or litigation, you must be very careful to preserve it. And that's done through something Nathan might want to talk about later, called hold notices, where you go through the company and you let all the relevant custodians know. The they should not be deleting this data. And once it came out in court, particularly in that sensitive discrimination type environment, that they had destroyed the data, the US court actually gave them a sanction, a penalty. And because it was a big international bank, the judge wanted to make an example out of them and fined them a few $1 million. In the scheme of things, it's not a huge amount for a big international bank, but it put a wave of fear through the entire financial industry in the USA, and that's why it was called the birth of eDiscovery, because all the banks followed and said, what do we need to do not to be the next one to be fined 5 or 10 million US for not having our data stored correctly. And that really gave birth to this whole industry, which now includes companies like Epic, who are there servicing companies for all these compliance needs. Do you want to talk a little bit about Europe, Australasia, etc.?
Yeah, sure. So just on the Zubilaki, that was prior to any rules being written in the US. So that case law was actually used when the 2006 rules come out around governing eDiscovery in the US. Europe had a practice direction that was adopted in 2008 or 2007, I think. Their e-disclosure process is slightly different. The US has a very broad e-discovery process, which is all-consuming and captures pretty much everything it can. I think that the UK e-disclosure, which is what Hong Kong's practice direction has been based on, is a little bit more based on the principle of proportionality, so that the costs of the case are relevant to the e-disclosure exercise. Europe has no discovery, so they don't have any actual duty to disclose documents. There's obviously a lot of regulatory activity and cartel activity and some big e-discovery exercises in Europe, but they don't have any actual rules regarding disclosing or discovery of documents. Australia, if we consider Australia as part of Asia, has always been one of the more progressive countries in e-discovery. A lot of the software, a lot of the e-discovery platforms actually originated in Australia. I guess it's a smaller market compared to Europe and the USA, but it's always been a leader in the e-discovery space. And I think they had a practice direction years and years ago that said any case with more than 200 documents has to go down the e-discovery path. So I think the courts in Australia have always been open and progressive to handling electronic data. Singapore, you probably know a little bit more about than I do, but they've been quite progressive and had laws around e-discovery for a few years now, and Hong Kong's adopted the same approach as the US. Do you want to talk about those two?
Just on the UK, the focus in the UK has been on legal reform for the last 15 years, and it started with Lord Woolf, with 2 O's, in 1998, basically came in and said, we've got a court system that dates back about 150 years, and it just doesn't work for today. And the big focus in the UK is on access to justice and use of resources properly. And so they've been working quite hard to keep litigation on all fronts within reason. And there are cases that I certainly have seen where the costs of litigating can exceed the amount in dispute. And that's a great concern for reformers. And so they've adopted this idea of proportionality. And in the US, for example, where normally people pay their own costs, there isn't that idea. It's justice at all costs, pretty much. And it means leave no stone unturned, fight till the last breath, and no matter what it costs, you have to go and produce every last document. And that creates some major problems, that if you are a large corporation and you're being, say, sued in a class action by some people who have lawyers that are doing it on a contingency to get a percentage of the winnings, and they claim $10 million US, and then they ask you for discovery of, everything that you've had for the last 30 years on some chemical because they're claiming for a toxic tort, and then you go to, your local eDiscovery consultant and say, how much will it cost? And they say 11 million. Then sometimes the right thing to do is to settle for 5, regardless of merits. And that's the way the system is in the US. It's being actively debated in Congress. There's actually some new federal rules of procedure that are coming out based on that discussion. But in England, it's very firmly against that, and the courts look at what are the costs of litigation compared to the benefit or the amount in dispute. And look, sometimes it is important to spend a lot of money on something for justice, but often it's not. And about a year ago, they implemented a second round of reforms, which are called the Jackson Reform Package, a name of another Judge Jackson. And there you actually now have to have costs budgets. And when you start the case, you have to go in front of the judge and say, here's my budget. This is what I expect to spend on witness statements and document production, and you have to justify it according to what evidence you're going to get and according to what is in dispute. So that's the place where they're probably the most advanced on proportionality. The Hong Kong courts in about 4 years ago adopted a package of civil justice reforms that are modelled on the UK regime. So there is certainly concepts of proportionality, cost efficiency, etc. in Hong Kong, but it's probably a little bit less extreme than it is in the UK. But the core concepts are there. And so when we came to do the eDiscovery practice direction, we also modelled them primarily based on the UK and around this proportionality. And the way it works in the document search function is, instead of having every document that could potentially be relevant, you're only entitled to ask the other party for documents that are directly relevant. And the second part of it is that the search needs to be reasonable. So, for example, looking through metadata that was mentioned before, or trying to look for deleted documents will not generally be allowed, because the cost of recovering data or looking through metadata is often disproportionate to the benefit in a normal run-of-the-mill case. But there are exceptions. There was a case called ACI a couple of years ago where an insolvent company, the liquidators, sued the auditing firm. And a whole bunch of people I know were involved in the case, and they were all set up for 6 months. I even met one of the QCs. It wasn't my firm, just friends of mine, who was there and said, yes, I'm here, and my family's going to come and visit me every month or 2 and so on. We'll be here for this case for 6 months. And it settled after a week. And the reason it settled after a week is that some electronic evidence was produced which showed that the metadata showed that a Word document which gave certain financial figures had been altered at a time which made it pretty clear that people had been fiddling with the accounts. And as soon as that evidence came out, the party who would be guilty of that immediately said, we're not fighting this anymore, and they paid an amount to the liquidator. So sometimes metadata can turn a whole case, as it did in that huge one, but often and most likely it's not. I've probably gone a little bit off topic there, but there we go. That was the UK. In Singapore, they introduced the eDiscovery in 2010, and what they did, which was different to the UK, which we've also done here in Hong Kong, is not introduce it across the board, because there is an education process which is very important, and being here today is one part of that. There are many, many seminars and people are learning about how to adapt their practices to this. And so if on one day you just say, all right, everybody has to comply with eDiscovery tomorrow, it will cause a lot of disruption and anxiety. So Singapore introduced an opt-in system, or sometimes it's called an opt-in, opt-out. So if you think, okay, I've got a lot of electronic documents, I want a framework, then you can take the court's framework and say, I'll adopt this. You can even be in an arbitration in Singapore or Hong Kong where there might not be a compulsory framework. You can say, why don't we adopt the court's framework? You might be talking to a regulator in Taiwan, and they might say, well, how are we going to have a protocol to deal with electronic documents? And you can say, well, guess what? The Hong Kong court has a practice direction in traditional Chinese characters that you can adopt today as a framework as to help you out. So it was put in Singapore as this sort of opt-in, or the court might say, I think we should apply it to this case, or the parties. And Hong Kong has, in a way, done that, which we'll talk about. I think you can cover probably the rest of Asia and mainland China, and I'll just say something briefly about state secrets.
Sure. Well, I think we're going to cover state secrets a bit later. But the rest of Asia, if we look at where eDiscovery happens in Asia, Japan is a big market, and that's typically a lot of IP type of cases there, or work in the automotive or electronics industry. And Korea is the same, a lot of the automotive and electronic type of stuff. It's typically regulatory or US-facing litigation. If you think about Korea, there's obviously Samsung and Apple's probably the most high-profile dispute almost globally in the past couple of years, and that's obviously got a huge eDiscovery element. And Taiwan's similar. Mainland China is probably where we see the biggest eDiscovery cases in Asia, a lot of the FCPA type of investigations. But mainland China's also got a lot of challenges. I think we've put there, they've got ad hoc corporate information governance. That's one issue. Like some of the challenges we face when there's a big educational gap in China. Some of the problems are they may be working with like a US outside counsel. The IT manager might speak only Mandarin and has absolutely no idea what eDiscovery is or what their obligations are. And we'll have a request to go on site and collect data, which I'll go into more detail about some of the collection best practice. But we'll get on site in China, and these guys have said you can't access any of this data. It's been deleted, or our data's hosted on a server somewhere else. We may do 2 site visits, and all of a sudden some of the hardware that was there isn't there the next time, or some boxes of hard copy or something may have magically appeared in its place. So there's a lot of challenges there, and there's a real educational process. Consent is difficult in mainland China. Quite often they don't understand what's required from a consent standpoint, let alone have any sort of forms or policies in place. So yeah, and we'll go into state secrets is obviously one of the main issues there, and I think we cover that in a later slide. We can talk about some of the workflows or best practice for managing state secrets projects where predominantly the data can't leave mainland China. If we look at who's responsible for making eDiscovery decisions, typically and traditionally it was the law firms. I guess that was before the corporations had any in-house knowledge. So litigation teams, regulatory teams within law firms were making eDiscovery decisions. US law firms will have big departments called litigation support or eData managers that are solely responsible for making eDiscovery decisions. We're seeing that changing quite a lot, and now the corporations are making decisions. They'll have a panel of eDiscovery providers globally, a bit like they would have a panel of law firms to act as their outside counsel. Within the corporations, the key departments dealing with electronic discovery are obviously legal, but increasingly compliance teams, risk, internal audit, and then obviously there's an IT element because they're controlling a lot of the electronic data.
So This is, I guess, related to the title of what we're discussing today, but I won't spend too long on it because it's fairly procedural. So I've covered some of this, that we followed the UK model. Where Hong Kong ended up is about a year and a half ago, they realized that every other court system has something dealing with digital data, and the court system here was still based around paper, and they realized that simply doesn't work. So the judiciary put a working group together, and it started originally with lawyers, and in our first meeting we figured out that we were not going to get anywhere on our own. So we invited some technology specialists. There's a bunch of companies that are in the same field as Epic, and Epic was one of those companies. And we all sat around and said, what do we need to do from a practical, a technical perspective, and from a legal perspective to make this work, remembering that we're going back to proportionality. And so to make sure that it is proportional and reasonable, there needed to be the technical input into the legal process. Eventually, the practice direction was published and has now been effective for a few months. And what I've underlined there in the first bullet point is the words fair and cost effective. So the court is balancing access to justice. The whole idea of discovery is that if my opponent has a piece of information that is going to help me beat him, he's got to give it up. Now that's an English concept. If you go to continental Europe or China or Japan or Korea and say the other party to the litigation has to give me a document that helps me and hurts him, the answer is no. You're not entitled to that. There's no legal concept to give you that. You produce documents, the judge makes an inquiry, the judge might ask the other party to produce something that doesn't help their case, but you don't have the right to ask it of another party. But in England and in Hong Kong and Singapore and Australia, we do. So that's the access to justice, your right to get information from the other party, but on the other hand, it's got to be cost effective. So you've got to keep it within reason, which means that you've got to look at the technical systems to allow you to do things proportionally, and that comes down to cost and methodology. What they did in England is they produced this questionnaire, and in Hong Kong we've adapted it as actually a shorter form. In essence, what it does, which is different from the old system, is the old system used to say, please list all of your relevant documents. And you would go through the file and you would put little yellow flags on every 10th or 20th document that might be particularly relevant, and then you'd produce a list of thousands of these, letter from A to B dated 2nd of January, and then everyone would need to look through it. That's not ever going to work with electronic data. So what the court now does is looks at it the other way around. The electronic data questionnaire asks you, what data do you have and what formats is it? Is it on a mainframe server? Is it on smaller servers? Is it on laptops? Is it on mobile devices? Audio, videos? What kinds of files are they? Are they Microsoft type files? Are they databases? What are we talking about? Instant messages. What are the numbers of people that are the key actors in here? You might have 5 or 6 key, what they call custodians. So you'd need to focus firstly on, say, their mail inboxes and then work from there and see if you need to look at anybody else's. So you get this idea of the digital landscape that is there. Now, the lawyers can't do this. So the practice direction very strongly encourages parties to get technical assistance, and we would normally recommend that that should be from an independent type of technical support, because your internal people may not have the right level of experience, and they may also, have some internal pressure or so on. So if you want to have a good sort of chain of custody, if you have somebody independent coming in, then you can show the court that everything has been handled properly. And the beginning of that is this questionnaire. Somebody eventually has to sign that under oath, or at least what's called a statement of truth, which means that if you say things that are untrue in there, you could actually be subject to a criminal penalty. I mentioned before about it being a pilot scheme, so it does not apply compulsorily to most cases in the court, but the court can find a case and say, even though it's not in the commercial list where the pilot scheme is, we'll apply it to there, or anyone who's in the court who thinks they want a framework can use it. So what that means, which is relevant to everyone, is that any company in Hong Kong today could tomorrow be involved in eDiscovery, whether they like it or not. Because if somebody sues your company tomorrow, they will have the right to ask for your electronic data. And it could be quite relevant to your liability. So what that means is that today you need to have a system in place that is going to facilitate that data being preserved and collected and searched if it is required for litigation either tomorrow or at any time in the next 5 to 10 years. So because of that, the document retention and document deletion policies are quite important. As I said before, if litigation is contemplated, then you have to preserve documents. And deletion is very important because most people think that you're not allowed to delete documents. Actually, you are. If you do not think that data is relevant to a potential litigation, then you can generally delete it unless there is some specific legislative requirement, such as the Personal Data Privacy Protection Ordinance that we'll look at in a minute. So you've got to think about what do you keep and what do you delete and when and how. And Nathan has something to say about that.
Yeah, I think it's probably more appropriate to call it a document or data management policy. Like I think that the document retention policy was back in the days when there was hard copy and you had physical constraints on how many documents you could actually keep. These days, it's important to have a policy in place that defines how long you need to keep a document and get rid of it when after the fact that you don't need it anymore, because it's opening up your risk if you're keeping everything, and it's causing headaches down the track if there is a discovery request. So you've got to sift through all of this, and it's part of the reason where this big data came from, because people are keeping everything these days. So I think a data management policy is more appropriate, but it is important to have a policy in place regarding your data. So yeah, if we talk about the starting point for any eDiscovery exercise is actually collecting and preserving the electronic evidence, which generally means either somebody internally doing it or somebody externally. And if we talk about internal versus external, as Menachem touched on earlier, electronic data is very volatile. It's prone to being spoiled or changed, or which can all be called into question. So by using a forensic expert, an external consultant that is certified in all of the tools, they can produce an expert witness report, they can stand up in court and testify to the methods, they can follow chain of custody exercises, and you can ensure that the data, when it was collected, has been preserved in what we call a forensically sound manner. So that can add some defensibility to the case. And if we look at the cost of an actual forensic exercise, it's a very small fraction of the overall eDiscovery exercise. So it can be beneficial to use an external consultant to preserve that data up front. Certain types of electronic data, like email, can be very easy for an IT department to extract and pass on to either a provider or the law firm or whoever is going to actually filter and process that data for review. If we talk about where is the data, it's important external consultants can do what's called data mapping, which Menachem touched on, which is understanding where your data is, producing an overall image of where the data resides, where the server is. Are we talking about handhelds? Are we talking about laptops? Is there cloud server space available? I just touched on, there's mobile devices, personal devices. There could be memory sticks, all sorts of ways that people back up things or send things to their Hotmail accounts. All these things can be collected in a forensic collection. Menachem also touched on deleted data recovery. Documents, if you hit delete on your laptop, that document's not deleted. At that point, you're just telling the operating system that it's not there anymore. That space, the actual document will still be on the hard drive and can be found if we use some forensic tools to recover that data. All it's telling the operating system is that space can now be written over, but I think it takes something like 7 attempts or the data can be written over 7 times before that document's actually gone. So when you delete a document, and even if you delete it from your trash can on your desktop, it's still there on the hard drive until it can take a long time before it's actually overwritten. And there's techniques that we can apply to actually recover those deleted documents. On-site solutions. So there's obviously forensic experts that can go on site and carry out a collection for electronic evidence. There's also things that we can set up on site, and this is particularly appropriate to maybe Chinese state secrets or a sensitive intellectual property dispute, whereby you can have consultants set up on site, potentially in like a conference room or somewhere at the client site to run some searches and filtering, so that data never goes online or never actually leaves the client site.
We've got about 2 or 3 slides of this text left. I'm going to go through those very quickly and then take some questions. I also want to just give Nathan a few minutes at the end to show you some of his latest slides of how a platform actually works. I'll just very briefly touch on these. It's fair to say that this slide is on its own a whole other seminar. Gabriella actually, as head of our intellectual property department at our firm, has just published about a 6 or 8 page note on the guidance that came out on the 29th of December from the Office of the Data Privacy Commissioner. I think it has bigger ramifications than probably anything that's happened in personal data privacy to date. We don't know yet when it will become formal, legally binding, but there's a guidance which suggests that it's coming. I find it interesting that the chief executive in his policy speech talks about Hong Kong becoming a world leader in data centers and cloud storage, but then this guidance essentially restricts that, because if you have data in a data center in the science park in Changquan'o, and you're in another country, it will be illegal for you to download that data unless you comply with these fairly severe restrictions. So I think the government's got a little bit of work to do in terms of balancing, on the one hand, its economic plan to become a leader in cloud storage, and on the other hand, it's justly wanting to regulate cross-border data transfers. But that's really for a whole other day. Europe is also increasingly becoming very restrictive, and from what I read up, the European Council is expected this year, they say, in 2015, to pass the long-awaited data reform, which everybody says will be stricter than what they already have. So in between Europe and Asia, I really don't know where we're going to end up with data protection transfers. But a lot of these regulations don't take into the account that if you are in another country and you look at an email on your phone, you're accessing data or downloading data from another jurisdiction and potentially breaching a whole bunch of laws. So that's for a whole other day. In Hong Kong, we deal daily with mainland China, state secrets. A lot of this came up with cases where some of the Chinese companies that listed on the US stock exchanges and the accounts weren't in order and so on. A lot of that, when discovery was sought in the US courts, they said, no, if you audit a mine in China, that's a state secret. So there's a lot of issues around that. There's been a judgment in an SFC and Ernst & Young case a few months ago where they had audit papers for a Chinese water company. And again, there were huge issues about hard drives that were in Hong Kong that contained audit papers for a mainland Chinese company. The first instance judge ordered Ernst & Young to produce them and publish an 80-page judgment looking at state secret laws. I understand that's going on appeal. So again, it's a whole other topic. One or two things to say about that?
Yeah, sure. So our experience with handling matters with state secrets is that most often the data can't leave China, number one, and to that extent it can't even hit a screen outside of China. So even if the data is residing on a server in China, the data needs to be reviewed within China. And that's typically by if there's a law firm acting for which there'll usually be a Chinese outside counsel. In some of the international cases, there'll also be a global law firm like Mayer Brown working with the Chinese outside counsel, and that review needs to take place in country in China. And quite often the first pass review is managed by corporate employees of the Chinese organisation. Did we want to take any questions at this stage, and then I can run through some of the technology that's available.
Thank you. It sounds like we have questions. Yeah, we do have questions, do we? I've got a few, but I'll just choose one. In terms of preservation of evidence, given that you've got multiple storage, so once you get an order from a court, let's assume it's any court, it can be from any country, but it's telling you as a global corporation, you've now got this preservation order. How on earth do you go about ensuring that everybody in your multiple jurisdictions and with multiple devices and possibilities is actually preserving that evidence?
Yeah, well, typically you need to have some sort of legal hold procedure in place, which there's systems that can manage legal hold, and what that will do is automatically send emails out to all the custodians, the key people involved, and notify them of the e-disclosure or eDiscovery request, and also tell them of their obligations. And typically it'll have like a button where they accept the legal hold and say they agree to comply with this. I'm sure a lot of companies that is sort of ad hoc and managed on a manual basis where it'll be communicated in an email that's physically typed and sent. But the more savvy or the larger corporations will have legal hold, which is sort of a whole other element other than the e-discovery, having a legal hold system in place to manage that. But it's definitely a challenge, and it's definitely a challenge with some of the things we touched on regarding numerous servers, numerous different devices and handheld type devices and cell phones and the way people communicate now.
And the related point is when you get the order for destruction of something, I'm talking about IP cases because this is an IP seminar. So let's say you've had infringing content posted somewhere and it's held on a server, you get a court order that says destroy it, and it's very challenging because there will be multiple copies, cache copies. There would be just so much, and it would be very difficult for that to go away, as we know with Google and the miscalled right to be forgotten, when in fact it's right to delink, and you delete some information, but it never disappears.
I mean, from an evidentiary point of view, if somebody said to me, how am I going to comply with a regulator's order or a court order to delete infringing content from an IP point of view, I'd do the reverse of finding data. So I would get the best forensic IT expert that I can and say, show me how you could find every last bit of data if we were looking for it, and then show me an audit trail of how you can demonstrate that you've gone through all the steps that you would go through to find the data, and then that you've gone in there and used all available techniques to destroy it irretrievably. And it's probably best that you do that through an independent, external forensic IT specialist rather than trying to get somebody in-house, because most corporations will not have that kind of ability. Are there any other questions at this time? What I was going to suggest is, rather than talking about this slide, Nathan can actually show you using analytics, conceptual analytics, analysis and technology-assisted review. This is a bit like this CES, Consumer Electronics Show that they just had in Las Vegas, with the Internet of Things and cars that drive themselves and things like that. It's pretty interesting stuff, so I'll let Nathan run you through it.
Sure. So the first point on that previous slide was service versus software. I think all these technologies are great, but it's the service that you can get around that. So what I would say is, if you're having an eDiscovery exercise, then meet the project managers or the client services at the provider that can actually support these types of technologies and make them sing, if you like. So this first slide is what, once we've collected the data, we're running some searches, and then we're putting it online for the legal teams to review. This is what a typical review platform will look like. So you'll have it'll look a little bit like Outlook. You'll have your document list there, which effectively is all the responsive documents. You'll have the document on the right, which is actually a view of the native document. In this case, it's either a Word document, it looks like. And then down in the bottom left there, you'll see a coding form, which is effectively where reviewers can make decisions, and the decisions will typically be around relevance or privilege or any issues in the case. And all that type of things is customizable in that view. Some of the technology that we can apply to accelerate reviews are what we call email threading. We touched on earlier that a document could be sent 10 times and that thread can grow exponentially as other people get copied or it gets forwarded. There's technology available to group the email together. So you can see there that that's indented each time there's a new email in the thread, but we can automatically group them together, and the green one down the bottom shows the inclusive email. So from a review standpoint, you can confidently review that last email, the green one, and be confident that that includes all prior communication in that thread, and then make a decision based just on that email, which will automatically code the 10 emails or whatever there is in the thread. We can also do near duplicate comparisons. So at the processing stage, after we've collected it, we run deduplication, which gets rid of duplicates. Email data by its nature is highly duplicative. The deduplication we run at the processing stage works off a metadata field, which is like the fingerprint of the document, and will automatically get rid of exact duplicates. But in its standard document set, there's a lot of near duplicate documents where it might be a header's different or a footer is different, or there might be one line that's changed, which can be frustrating for reviewers because for all intents and purposes, they see it as the same document. So we can group the near duplicates together, and if you look at that left-hand column there, assign a rank to how closely they are related. And then we can also do a comparison, if you look at the box down the bottom, whereby you can see the changes and then quickly make a decision based on, if there might be 20 documents in that group, you can make a decision based on all of them.
Just before you move on, I see in your red box it says compare with Equivio text compare, and in the tech news this week it was announced that Microsoft has just bought Equivio. So you've got the world's one of the world's leading tech companies that has just invested, I think, $200 million in a leading eDiscovery technology, and this is actually unusually a technology that was developed in the eDiscovery area, but is now being applied in a broader sense. And essentially, what Equivio does is it's able to look at large amounts of data through these algorithms, which is why you've got this compare text, and start noting patterns and differences between data. and Microsoft sees that as something that it will introduce into its broader Office suite type platforms. You know a little bit about that.
I don't know anything about what they're planning, but generally, they'll be using it as more of a proactive sort of approach, and possibly have like an eDiscovery module built into Microsoft Office to make getting the data out a lot easier, and also probably proactively apply some of the analytics and the algorithms to data to flag things like potential breaches in policy, or track some employee behaviour for compliance proactively. So there's also concept clustering. So before we put the data into these databases, we're typically running some keyword searches, date filtering, and that type of thing. What's becoming more used is to run some concept clustering, which again is applying an analytics engine to the data, and you're just pointing the analytics engine at a raw set of data. So it might be just one custodian, or it might be a whole set of data, and then the system is coming back and grouping these concept clusters together based on how similar they are to each other, and assigning a rank and a name. So you'll see that in the red box there. And how that accelerates the review is typically, once we're batching these out to like Menachem's team in a law firm for review, it's just by custodian. But that custodian or person could have a whole different array of concepts that aren't really related and take time to understand within their set. Whereas with concept clustering, you can confidently group similar concepts together and assign them for review to an expert in the field. So all the accounting documents can go to someone with a financial background, all the engineering documents can go to an engineer, and so on and so forth. So that can accelerate review where you've got a subject matter expert reviewing similar concepts. Technology-assisted review takes that to the next level. And what if we look at those coloured squares there, that's your typical data set. You'll have some relevant documents, irrelevant documents. You'll have some that are crucial to the case, but they could be all over the place. So we can use the analytics, and this takes some user input from some subject matter experts or legal experts with knowledge of the case. We can take that information, we can train the system and say, this one's crucial, this one's irrelevant, this one's relevant, and train the system so that it can align all these together. And after a certain amount of sampling, we can, once we've got that confidence level up, we can make decisions based on the data set. And for instance, like there might be 100,000 documents in a population. If a subject matter expert can code, say, 5,000 or 6,000 of them, we can then train the system and say, go and allocate that same coding decision to all the similar documents, which can accelerate a review immensely. So there's a couple of slides here on technology-assisted review. That's the interface. That's the Equivio interface. So that you'll see the documents as you walk through, and down the bottom there, it's you're simply training the system and making a decision, responsive, not responsive, or skip. And then you'll see here you can get an analytic graph that will show once there's a confidence level and a rating of usually around 80%, then you can go ahead and say, go and code the rest of the documents with that same decision. Any questions, or did you have any comments about?
Last slide.
Okay. The final one was, audio searching, which is particularly relevant in Hong Kong. A lot of the financial institutions, a lot of the trading floors are producing a lot of audio data. What we can do now is keyword search the audio data like it was a normal document, and then skip to that particular, you can see the WAV file down the bottom there, skip to that particular moment in the audio, which can, I think there's some metric that an hour of audio data takes something like 3 or 4 hours to actually review, whereby if we can skip to that particular moment in the audio and make some coding decisions based on that, it can save a lot of time. And that's becoming more prevalent. We're seeing a lot more audio data, especially in the regulatory investigations in Hong Kong for the financial institutions.
And the final comment from me, because our time's up, is what you've just seen is replacing a lot of human review time with the best available technology out there. And Litigation, investigations is often criticized that it takes up millions of dollars to review hundreds of thousands of documents, audio, etc. And what's now coming forward is the ability to match the humans and the artificial intelligence and to look through a huge amount of data and come up with the core data set with the concepts that are going to be relevant to you, and then you do a human review and run your case based on that very small data set. You've taken the needle out of the haystack, essentially. Final comment?
Yeah, and there's increasing case law around the whole technology-assisted reviews, mainly coming out of the US, but it sort of makes sense. And I think what it's doing is putting the onus back on the law firm and the legal experts and the subject matter experts, rather than just reviewing millions and millions of documents and the corporate clients spending a fortune. It's putting the onus back on the law firms and the experts in the field to do what they do best, which is review the relevant data.
We have a question.
Hi. You keep talking about the expense and the cost and millions of dollars, but you seem to have skipped about any actual cost yourselves. And what are we really talking about? Like in Hong Kong, we have the majority of SMEs. So what are we talking about? Cost 10,000, 100,000, a million?
Well, it depends really what it is that you are involved in. If you are an SME and you have less data, then obviously you're not going to incur that enormous amount of costs. But what you will find is you might have a dispute where there might only be 1 million Hong Kong dollars in dispute. And in fact, the effort you need to look through a set of documents might be the same as a 10 million. So in fact, the risk of costs going out of control is even bigger. But it's good news that certainly the courts in Hong Kong are aware of that. And when we said before, the amount of effort and money you spend on looking through documents and evidence needs to be proportional. So the court, if they see that this is an SME case, will try and order a very unsophisticated and cheap kind of discovery exercise. They might say, why don't you use a USB stick? Why don't you use a CD? Forget about all this really fancy stuff. How can we keep this data exercise within a reasonable cost that is going to be affordable for this type of dispute?
Yeah, and there's ways to, you may only focus on a particular element of your data rather than the broader spectrum of the data. There might be a key person, or, there's filtering techniques so that you can hone in on the actual data rather than go through a whole broad eDiscovery exercise.
Well, how would you charge on these? We still haven't come to any sort of a dollar figure.
No, so it's relevant to the gigabyte volume, so the data size. So it completely depends on, if you've got 1 gigabyte or 100 gigabytes of data. So it depends. And that a small or medium enterprise could still have a large amount of electronic data.
Do you charge by the gigabyte?
Yes, typically. Sometimes there's an hourly charge.
Hourly.
For actually collecting the data is typically hourly. For the actual processing or filtering of data or hosting data, that tends to be per gigabyte.
All right. Well, thank you all very much for coming today. We're just beginning a journey of eDiscovery, and possibly in about a year and a half to 2 years, we might invite Menachem and Nathan again to tell us where we are and what has happened in the meantime. But I'd like to, on behalf of the Chamber, thank our speakers as a little gift. Thank you very much. And thank you very much for coming.
Thank you.
Thank you.